The next matter to come before the court this morning is James Fry et al. Versus Grace Speelman. We are a couple minutes early. Are we expecting anyone else to be here this morning? Okay, come on up. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. I note that we have a cross appeal in this case, but as you are probably aware, the way the court goes about this on oral argument is the person that's listed as the appellant has the 15 minutes with 5 minutes of rebuttal, and the appellee/cross appellant has 15 minutes in the interim, in the middle of that. So the court's read the briefs, and we're ready to proceed when you are.
Good morning, Your Honors. My name is Aletha Carver, and I am here from the law firm of Krugdak Wilkins, and I'm here on behalf of the appellant, Mrs. Grace Speelman, and I would like to reserve 5 minutes for rebuttal, please. My presentation to the court this morning is going to touch upon 3 main points that we raised in Mrs. Speelman's brief. The first one being that the right of first refusal was not triggered under paragraph 2.01 because Mrs. Speelman did not have a desire to sell the property. The second point is that the transfer of the property to the Mowers did not trigger the right of first refusal because a transfer is not a triggering event under the right of first refusal. And the third point is that the Frys are not entitled to specific performance because such relief would be harsh and oppressive in this matter, and they have not proven any damages. Now, I am aware that the court has read the briefs. I would just like to briefly talk about the language of the right of first refusal. There are 2 separate paragraphs that are under consideration. Under paragraph 2.01a, the right is triggered if Mrs. Speelman desires to sell the property. And under that situation, then, she is required to notify the Frys of her desire to sell, and then they have 30 days within which to exercise that option, and they can purchase the property for $10,000 an acre. Now, if the Frys decide not to purchase the property under the first paragraph, paragraph 2.01b kicks in, and that gives Mrs. Speelman the right to list the property for sale to a third-party purchaser. And if she receives a bona fide written offer, then she has to present that offer to the Frys, and they have an opportunity then to purchase the property under the same terms and conditions of that offer that she's received from the third-party purchaser. There is also one other paragraph that's in dispute in this case, and that is paragraph 2.02, and that deals with the provision where Mrs. Speelman has a right to transfer the property to her children and 1 grandchild without triggering the right of first refusal. Now, as to the first point that I would like to make, the trial court found that the transfer of the property to the Mowers triggered the right of first refusal. But it is our contention that the transfer is not a triggering event under the right of first refusal. Instead, it is Mrs. Mowers' desire to sell the property that actually triggers the right of first refusal. Therefore, the court should not have ordered specific performance in this case under section 201A because a transfer of the property is not a triggering event. Now, this court was faced with a similar issue in the case of Lees versus Meyer, and we discussed that on page 10 of our brief. And that case actually dealt with an option agreement. In Lees, the option agreement provided that appellant would have a right to purchase the property at the time appellee no longer desires to reside in said home. Appellant argued that because appellee was no longer residing in her home, he had a right then to purchase the property under the option agreement. On appeal, this court took a close look at the language of the option agreement as well as the evidence in the case, and they found that although appellee was no longer residing in her home, the fact was that she never expressed her desire to no longer reside there, and therefore this court concluded that the option agreement had not been triggered. Now, the Frys tried to get around this particular argument by focusing the court's attention to paragraph 2.02 and arguing that Mrs. Speelman was only permitted to gift the property to her children and her one granddaughter. And I would first note that although the Frys do raise that argument in their motion for summary judgment before the trial court at no time addressed that portion of the argument in its judgment entry. And I would submit to this court that it should not do so for the first time on appeal. Also, this particular argument overlooks the fact that the desire to sell is not the triggering event under the right of first refusal. And you should look at to whom the property may be transferred to in determining whether a triggering event has occurred. And the Sixth Circuit Court of Appeals addressed a similar issue in Evans versus SC Southfield, which we reference on page 4 of our reply brief. And in that case, the court had a similar clause where the property could be transferred to particular people without triggering the right of first refusal. But the Sixth Circuit Court of Appeals refused to consider that language and instead focused on what was required to trigger the right of first refusal, which they said was a desire to sell and a bona fide written offer. And the Evans court ended up saying that the relevant question was whether the proposed transfer would support the valuable consideration in determining whether there was an intent to sell. And ultimately, the court concluded there was no desire to sell or a bona fide written offer, so the right of first refusal had not been triggered. And we really have those same facts here in this case. There was no desire to sell by Mrs. Speelman. She transferred the property to the Mowers. She did not receive any consideration for that transfer, and there was never a bona fide written offer between
Well,
the
she
parties.
at least had received past consideration, she said, really, right? Because for the care, her care.
I
She
mean,
says
that-
that this is in return for all you've done for me and what you'll do for me in the future.
And there's case law that indicates that we agree with that goes more to a donative intent, that I'm transferring this property to you because you cared for me following my husband's passing, you cared for my property, and you've agreed to do so in the future.
And she put the $25,000 on it, obviously, too.
Yes, but she never received
But she didn't say,
any compensation.
but this may be somewhere in the middle, but it's clearly not just an outright gift.
Well, we would argue
Okay.
that the transfer goes really more to her motivation for the transfer as rather than consideration. And
But I mean, the
believe
$25,000, she said when you have it, but it's not
Right.
like she said you never have to pay a penny for this.
that- No, she never said that. No, I can't stand up there and
Yeah,
represent that.
I'm
but-
just trying to figure that out.
That's fine.
How would you deal with the scenario that a conveyance fee was actually paid and it went through the county offices as if it was a sale?
Yeah, I think this court has the ability to look beyond just what you're seeing on a piece of paper, and I think there are a number of factors in this case that indicates that there wasn't a sale here. And I mean, I would first point out to the court that the trial court even said in its judgment entry, I think the first sentence of the judgment entry was that the question of consideration is still an issue of material fact here. The court never referenced this as a sale. It referenced it through its entire judgment entry as a transfer. So that is one factor that I think the court can look at beyond just what you're seeing on a piece of paper and saying, well, it looks like a sale to the court. There are other factors as well. The fact that they never entered into any type of a purchase agreement. That is one factor that the court can look at. The sale price was far below what the Wayne County auditor had valued the property at, which was approximately $82,000. There was no written note evidencing any kind of a debt owed from the Mowers to Mrs. Speelman. So those are some of the factors to answer your question, Judge. How do you get around the fact that we do have this written document showing that there was some type of transaction in consideration?
Thank you.
I also wanted to point the court to the fact that the transfer of the property was not a sale. And this goes back to what I've already said, that the court found that there was no consideration, or that consideration is still a question of material fact to be decided in the case. And the court described the transaction as a transfer and not a sale. This case can really be likened to the decision from the Idaho Supreme Court that we reference on page 12 of our brief. It's the Isaacson case. And in that case, the son actually paid the father $20,000 for a farm, but the court found that the option to purchase in favor of the lessee had not been triggered despite that. And the court relied on several factors in reaching that conclusion. First of all, the court found that the property was worth 3 times what the son had paid for it. The court also noted that the father demonstrated a donative intent based on the son's agreement to care for his mother into the future. And the transfer didn't impact lessee's right to exercise that right of first refusal in the future. It remained in effect. And that's really the same facts that we have here. Again, according to the Wayne County Auditor, the property is valued at approximately $82,000.
And you just now reaching 5 minutes. Continue or reserve as you wish.
Okay, all right. So again, I would just say that the Isaacson case is similar to the facts of this case, and we would ask for the court to consider that. And I would also mention that as to the third point regarding specific performance, we would ask that the court look at its decision in Swartz versus Bryce, and that is where the court said that if specific performance would be harsh or oppressive, it would not enforce specific performance. And we would state that that would be the case here because Mrs. Speelman did not have a desire to sell the property. And also, the appellees were required to prove damages, reasonable certainty damages. There are no damages here. The property was transferred back before this lawsuit was even filed, and the right of first refusal remains in effect at this point, so it can be exercised in the future, $10,000 purchase price per acre. So with that, I will sit down and reserve the rest of my time. Thank you.
Good morning. May it please the court, my name is Sarah Baker, and I represent the appellees and cross appellants, James and Diane Fry. This case is really quite simple. Mrs. Speelman willingly entered into a contract with the Frys. The Frys complied with their end of the bargain, and then Mrs. Speelman changed her mind and chose not to uphold her end of the deal. The law does not permit such action. While opposing counsel attempts to seek sympathy for Mrs. Speelman, claiming she didn't desire to sell the property, it should not be lost on this court that Mr. Fry warned Mrs. Speelman prior to her sale of the property to the Mowers that doing so would violate the terms of the agreement. And then she ignored that warning, sold the property to the Mowers anyway, and when she got caught, she quickly tried to undo that transaction. Mrs. Speelman's desire to sell the property and her actual sale of the property to the Mowers triggered the Frys' rights under the agreement at issue, and specific performance is the proper remedy. With regard to triggering the first option, it's important not to lose sight of the language of the agreement itself. The question before this court is whether Mrs. Speelman desired to sell the property to the Mowers. It hinges on her desires, not on this court's ultimate determination about whether the transaction was more of a gift than a sale. Her own testimony unquestionably reflects that it was her desire to sell the property to the Mowers. On page 20 of her deposition, she testified that she told her kids she was going to sell the property to Michael Maurer. In paragraph 20 of her affidavit, she indicated she was willing to sell the property to Michael Maurer. When asked if she ultimately sold the property to the Mowers, she testified and responded multiple times, "Yes, I did." These are not my words, these are Mrs. Spielman's words. These are her desires, her intentions. So whether this court were to ultimately determine that the transaction itself was more of a gift than a sale, it is really irrelevant to the question of whether or not Mrs. Speelman at the time desired to sell the property. Lending further support to the argument that Ms. Speelman intended this to be a sale is the fact that she didn't treat it as an exempt gift with the recorder's office. In fact, she paid the conveyance fees associated with the $25,000 purchase price. The court shouldn't be distracted by counsel's efforts to now characterize the transaction as a gift, when a review of the lower court record will reveal that not once did Mrs. Speelman or the Mowers refer to this transaction as a gift. The record simply does not support the argument that she intended this to be a gift. To the contrary, it's filled with references of her intention to sell the property. Without first giving the Fries the opportunity to exercise their rights under option 1 or option 2 of the agreement, an opportunity that Mrs. Speelman knew the Fries would exercise. Because Mrs. Speelman's desire to sell a loan was sufficient to trigger her obligations under option 1, she violated the agreement, and this court should affirm the trial court's finding that option 1 was triggered. With regard to triggering option 2 of the agreement, or 2.01b, if you will, Mrs. Speelman undeniably received an offer that she wished to accept. There's no dispute that the oral agreement between Mrs. Speelman and the Mowers was that the Mowers would pay Mrs. Speelman $25,000 for the property, with the amount to be paid whenever they were able. The issue before the court is whether option 2 was in fact triggered by that offer and acceptance and consideration, whether that constituted a sale to a third party under the terms of the agreement at issue. And it's important to focus on the terms of the agreement that we have here in this case. Lots of other cases have been cited in both of our briefs, but none of the agreements that are cited, or none of the agreements in these other cases included section 2.02 of this agreement. None of those agreements included a section specifically addressing transfers and gifts of the property to certain family members. In this case, Mrs. Speelman signed an agreement, and in fact changed that agreement to specifically reflect her desire to be able to transfer, gift, devise the property to children or a specific granddaughter, Jennifer Rockwell. Mr. Maurer, and definitely not, Mr. Maurer and his wife were not included in that. And the mantra of expressio unius, if you will, forgive my Latin, it would suggest that by specifically excluding the Mowers from that, the intent of the parties was that a transfer, a devise, a gift to the Mowers, or to anybody else that wasn't specifically listed in the agreement, was subject to the right of first refusal at issue. That provision is nowhere in any of the cases that are cited. And opposing counsel has referenced numerous cases in which the courts have found that where there's language in the agreement about a desire to sell, a gift for no consideration does not trigger the agreement. I agree. That's just simply not the case here. There was an agreement to pay $25,000, and as a result of the offer, the acceptance, and the consideration, there was a sale of the property here. Furthermore, a sale needs to be given its plain and ordinary meaning. And even the cases cited by opposing counsel, Miracle v. Wolf and Park Station, reference Black's Law Dictionary and indicate that a sale contemplates a vendor and a buyer, and the transfer involves payment or a promise to pay a certain price or money in exchange for its equipment. Accordingly, this was a sale. There's no question that there was an agreement to pay $25,000. The fact that they had not yet exchanged the $25,000 is irrelevant to whether or not this was a sale. Opposing counsel has cited one unbinding case from Idaho where a court determined that sale of property to a child for less than market value was more of a gift than a sale, and not a sale as contemplated by the lease at issue. That's a very important distinction. It was not a sale as contemplated by the lease at issue because, again, in Isaacson, there was no provision in that lease, in that right of first refusal, that dealt with giving the property to certain family members, one of which excluded the son. That fact just didn't exist in Isaacson. And furthermore, if you look at the analysis that the court goes through in Isaacson, you'll see that they liken the transaction to a conveyance to a family corporation controlled by lessors, or a transfer by a corporate lessor to another corporation controlled by the same owners. In other words, they're likening the transaction in that case in Isaacson, the gift from the father to the son, as almost a transfer to oneself. And that's certainly not the case here. Here, the parties contemplated gifting, transferring to certain family members, and the Mowers were excluded from that. The agreement at issue was specifically changed to reflect Mrs. Speelman's desires. Arguing now that it wasn't what she intended and enforcing it the way that it was drafted flies in the face of the evidence. Her argument that enforcing the agreement that she signed is harsh and oppressive simply doesn't make sense. It cannot be harsh and oppressive to enforce the agreement that somebody willingly signs and then chooses to ignore the agreement, ignore warnings that violating the agreement, selling the property, will result in this exact result, and then ignoring that warning and doing it anyways. She knew this might happen, or she could have known, or should have known that this might happen if she had simply read the agreement that she signed years before she actually engaged in the sale of the property to the Mowers. Because Mrs. Speelman desired to and sold the property at issue to the Mowers for an agreed-upon purchase price of $25,000 without providing the Frys an opportunity to exercise their rights under the agreement, this court should affirm the portion of the trial court judge's order indicating that option 1 was triggered in granting specific performance, and reverse that portion of the trial court's order suggesting the amount of consideration for the sale was unclear, and issue a finding that because no question of fact exists regarding the consideration, option 2 was triggered and the Frys should be granted specific performance as to option 2. I have nothing further for the
Did your
court.
clients ever document their, as this called for by the agreement? Didn't they have to send a letter or somehow put it in writing, their desire to match the third party's offer?
Your Honor, the requirement was that once my clients were notified in writing of the offer, that they
30
were,
days to match it.
they had 30 days to match it, but they were never informed in writing of the offer. Mrs. Speelman did say in passing once to Mr. Fry that she was going to sell the property to Michael Maurer. He told her she couldn't do that under the agreement, but she never provided him with notice of the terms of that sale so that he could match it. There was nothing that he was aware of that he could match, but certainly had he known, he didn't discover that the property had been exchanged for $25,000 until he saw the transfer of the property in the newspaper. So while she had mentioned that she wanted to sell it to him, to the Mowers. She never provided the written notice required under the agreement that would permit the Fries to exercise their option.
And why wouldn't we send it, if we agree with you, why wouldn't we send it back on the consideration issue to determine if the figure is 25,000 or 87,000?
Well, Your Honor, I think that if you determine that the trial court was wrong about the question of fact as to consideration, and that consideration was clear, then I think that there's nothing left for the lower court to decide, because there was a sale for clear consideration, and as a result, she violated the second provision of, or the second option of the agreement by not giving them the option to do so. She should not be rewarded in getting a higher price simply because she tried to skirt the terms of the agreement. It's certainly something that we could live with, remand to the lower court. I'm just not sure what they would determine if your decision is that consideration was clear. Do you have any other questions?
Seeing none, thank you.
If not, thank you for your time.
Counsel, you have almost 4 minutes left, 3:42.
Okay, all right. I'll try to talk fast. To follow up on your question, Judge, of course, we don't want the court to find that paragraph 2.01B has been triggered, but if the trial court, or if this court would find that to be the case, we absolutely do agree that it would have to go back to the trial court, because the trial court in its decision has clearly said that the whole issue of consideration is up in the air, that a question of material fact exists regarding consideration, and in order to have the transfer or the purchase occur under 2.01B, they have to meet the terms and conditions. And obviously, the sale price would be part of the terms and conditions of the agreement. So if the court would happen to find that 2.01B would apply, which again, I strongly believe that it doesn't, yeah, we'd have to go back to the court to address the consideration issue. Now, we've heard comments about this being a sale over and over, the fact that Mrs. Speelman mentioned this is a sale. But as I've said to the court earlier, the court can look behind those terms and look at what actually happened in this case, and the fact that we don't have consideration paid clearly goes against any kind of notion that there was a sale in this case. Also, under paragraph 2.01B, Mrs. Speelman, in order to trigger that provision, has to offer the property for sale to a third-party purchaser, and she has to receive a written offer. Neither has occurred here. She didn't offer the property for sale to a third party, and this was a transfer as noted by the trial court. It never one time referred to this transaction as a sale in its judgment entry, and she never received any type of a written offer from the Mowers. Appellees have made the contention that strict compliance with the language of the right of first refusal under, as written in the agreement, would result in absurd and contrary intentions, and it would allow Mrs. Speelman to sell the property without ever having to put it in writing. But we pointed out in our brief that that would clearly be against the statute of frauds. She could never just sell the property to a third party and not have that transaction be in writing. There's also an argument in the Fry's brief that under paragraph 3.02, the word written is not in front of the word offer, and therefore it eliminates the requirement to have a written offer. and that argument was not raised at the trial court and should not be considered here. And they are relying on paragraph 2.01B, which clearly does require a written offer. That language is contained in there. We would ask the court for all of these reasons to reverse the decision of the trial court, granting summary judgment and ordering specific performance in favor of the Fries, and remand this matter to the trial court to enter summary judgment in favor of Mrs. Speelman. And in the alternative, we would ask that the court remand it to at least address the issue of consideration, and we would also ask the court to overrule the Fries cross appeal. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a decision. It will be mailed to both sides as well as posted on our website, well, posted on the Hot Supreme Court website, which you can access directly or through the 9th District Court of Appeals website. Thank you. We are adjourned.